and hello everyone, I'm Hazirah Nisa binti Haznizam. Today, my team and I will continue with chapter 7.1, which is Introduction of Main Parts of OSH Act 1994, also known as Act 514. So what is this all about? They are basically the guidelines on occupational safety and health. As stated here, Occupational Safety and Health Act OSHA was enacted on 25 February 1994 to ensure safety, health and welfare of all persons at all places of work. This act contains several sections and are divided into several parts. Now, are you ready? Let's learn together.
Assalamualaikum and hello everyone. My name is Luqman Hakim Yuzaimi. I'm going to present about philosophy of OSHA and part 1 preliminary. Philosophy and principle of OSHA. It is responsible on safety and health at workplace, where it lies on those who create the risk and those who are working with the risk. It is involved three factors, which is concept of self-regulation, consultation instrument, workers participant, involvement and cooperation. Part 1 Preliminary. Section 1, Subsection 2 and Subsection 3. It is a short title and application, where in this section, this Act cited as Occupational Safety and Health Act 1994. Subsection 3 indicates where this Act shall be applied throughout Malaysia to the industry specified in first schedule. Section 2 stated that this Act shall be in addition to and not a derogation of the previous of any written law related to the OSH. It is applied to all economic sector in first schedule except for those who are working on merchant ships and armed force. Following our first schedule, manufacturing to make something into finished product using a raw material. In example, manufacture food, beverages, textile, woods product and others. Mining and quarrying. In example, coal mining, petroleum and gas, and stone quarrying. Construction activity of construction, extension, installation, maintenance, and related to the Construction Industry Development Board Malaysia, Act 1994, Act 520. Agriculture, forestry and fishery. In example, paddy farming, oil plantation, logging, and coastal fishing. Hotel and restaurant. Hotel is commercial establishment where people pay for lodging, meals, and other facilities, while the restaurant is a place where meals and drink are sold. Wholesale and trades. It is a business of buying and selling goods at discount price and directly to the customers. Transport, storage, and communication. Transport to carry people or goods. In example, lorry, taxi, and bus. While storage, storing goods. In example, warehouse. Communication, in example, are TV and radio. Finance, insurance, real estate and businesses service, such as financial institution, real estate management, legal services and accounting. Public services, statutory authorities. In example, education services, welfare institution, local authorities, and universities. Utilities, in example, gas, water, and sanitary services, where related to the public health. Section 3, Interpretation, Tafsiran, consists of 8 terms in OSH, which is first, occupier, second, plant, third, employee, employer, self-employed person, principal employer, immediate employer, fourth, place of work, fifth, as far as practicable, sixth, premises, seventh, risk, and eighth, work. Occupier. Occupier is related to the workplace, where it is mean a person who is in charge of the management or control of the workplace. Example, CEO or managers. Plant. It is include any machinery equipment, appliance, implements, and tools. Any component fitted, connected, or appertaining thereto. Appertaining territory, it is land of owner. Employee is a person who is employed for wages under a contract services, who is directly employed by the principal employer on any works of incidental or preliminary to or connected with the works, who is employed by or through an immediate employer at a place of work of the industry or under supervision of the principal employer or his agent on work which ordinarily part of the work of the industry, who services temporarily lend or let on hire to the principal employer by the person with whom whose service are so lent or let on hire has entered into a contract services. Employer, the immediate or the principal employer, it can be both. Self-employed is an individual who works for gains or reward, otherwise under a contract employment, whether or not he himself employs other people. Principal employer, owner of an industry or the person with whom an employee has entered into a contract of services and includes a manager, the occupier of workplace, the government in measure, such as department of any government sectors. Immediate employer, a person who has undertaken the execution at the workplace, where the principal employer is carrying on his trade, businesses, profession, vocation, occupation, or calling, under the supervision of the principal employer or his agent of the whole.
Assalamualaikum and hello everyone. My name is Fatin Atiqah. Now we are still in the same part, which is preliminary. I will continue the previous section for further explanation in terms of interpretation. So place of work is a premise where person work or used for the storage of plant or substance. It can also be said to be the location where the persons perform their job, which used to determine their economic characteristics and also the status in employment. So number 9 is the next interpretation, which is as far as practicable. So as stated here, it is the severity of the hazard or risk in question. Next is the state of knowledge about the hazard or risk and any of removing or mitigating the hazard. And it is also the availability and suitability of ways to remove or mitigate the hazard or risk. And lastly, it is the cost of removing or mitigating the hazard. And in a simple word, it means that the degree of risk in a particular situation can be balanced against the time, trouble, cost, and also physical difficulty of taking measures to avoid the risk. So the next term is premises. Premises can be defined as a piece of land with its building. And not just that, premises also can be any vehicle, vessel or aircraft, any installation on land, offshore installation, and other installation whether on bed or floating on water. Premises also can be any movable structure such as a tent. So now let's move to interpretation in section 3 subsection 2, which is risk. But before that, let's recall on what we have learned in previous lecture on the meaning of risk itself. So risk is the chance or probability that a person will be harmed if they exposed to a hazard. So when risk is arising out of activities of person at work, they shall be treated as the manner of conducting an undertaking, the plant or substances used, and the last one is the condition of the premise used. So next is subsection 3, which is the term of work, which means work as an employee or self-employed person. So now we know that work can be as an employee or self-employed, and an employee can be considered to be working in the time when he is at his workplace, but not if otherwise. For an example, being an employee under the government entity or any other institution. And while for self-employed person is at work thought such time as he devotes to work as a self-employed person. They work for themselves in a variety of trades, profession and occupation rather than working for an employer. As for example, self-employed can be a writer, an actor, and many more. Now we are still in part 1, which is preliminary, but move to section 4, which is object of the act. So the object of the act are to secure the safety, health, and also welfare of person at work against risk to safety or health arising of the activities of persons out of activities of the persons at work. Next is to protect the person at the workplace other than the person at work against risk to safety or health arising out of the activities of person at work. Number 3 is to promote occupational environment to the persons at work which is adapted to their physiological and also psychological needs. Lastly is to provide the means whereby the associated occupational safety and health legislation may be progressively replaced by a system of regulation and approved industry code of practice operating in combination with provision of this act, which designed to maintain and improve the standard of the safety and health. In simple words, the objective of the Act is an outline the underlying purpose of the legislation and can be used to resolve the uncertainty and also the ambiguity. Okay everyone, so now we just move to part 2, section 5, which is appointment of officer. This section explains that the minister may appoint from among public officers such as number of Deputy Director General, Director, Deputy Director, Assistant Director and also Occupational Safety and Health Officer as may be necessary for the purpose of this Act. And the Minister itself shall appoint a public officer to be the Director General of Occupational Safety and Health for the purpose of exercising the power, performing the function and also discharging the duties which assign him under this Act. And if there are any reason that the Director General itself is unable to exercise his power in duties, then the power shall be had and may be exercised and the duties shall be discharged by the Deputy Director General. Now is section 6. Section 6 is about appointment of independent inspecting body by the Director General. In this case, the Director General may, as he deems fit, to appoint a person or an independent inspecting body from any of the industry to advise or assist him in carry out the object and purpose of this Act. So, an independent who inspecting body appointed under subsection 1 shall be paid such allowance, fees, or reimbursements as the minister may determine. And not just that, an officer who appoint under subsection 5 and 2 and an independent who inspecting body appointed under subsection 1 shall be subject to the control, direction and supervision of Director General. And lastly, all the officer or Director General who appointed under subsection 5 and 2 and subsection 1 shall be deemed to be a public servant within the meaning of the Penal Code in Act 574. Now we are already in last section in part 2, which is section 7. So section 7 is about certificate of authorization. The Director General shall issue to every officer who appointed under this Act a certificate of authorization which shall be produced on demand to the occupier or anyone in charge. But the thing is, the certificate of authorization just shall be issued by the minister. So generally, this authorization issued is to certifying the staff by the organization and specifies the fact that they may sign a certificate of release to the service within the limitations stated in the such of organization or such of authorization.
Hai, Assalamualaikum. Saya Muhammad Syafirul Nazreen bin Ridzuan akan menerangkan berkenaan section-section yang terdapat di bawah bahagian 3, 4 dan 5. Now let's we go to the part 3, which is National Council for OSH. Section 8, Establishment of the Council. They shall establish a council called the National Council for the Occupational Safety and Health. Section 9. Membership of the Council. The Council shall consist of between 12 to 15 members, which 3 from the organization representing the employers, 3 from the organization representing the employees, 3 or more from the ministries or department whose responsibility is related to OSH, and 3 or more of whom at least one shall be the female from the organization or professional bodies. Section 11. Powers and the function of the Council. There are 9 powers and function of the Council, which are: change it considers desirable to the occupational safety and health legislation, the improvement of the administration and the enforcement of OSH legislation, the fostering cooperative consultative relationship between the management and the labor on OSH, the special attention to welfare of women, handicapped person in the community, the establishment of the adequate method of the control of industrial chemical at the workplace. Other than that is the statistical analysis of the occupational related disease, death and injuries, the provision of the healthcare facilities at the workplace, adopting industrial code of practice that related to the occupational safety, health and welfare, and the last one is the development of rehabilitation plans and facilities to assist person injured at the workplace. Now let's move on to the part 4, general duties of the employers and self-employed persons. Section 15, subsection 1, general duty of the employer and self-employed person to their employees. It shall be the duty of the every employer and every self-employed person to ensure that, so far as is practicable, the safety, health and welfare at work of all his employees. Now let's continue to the subsection 2 under the section 15. Without prejudice to the generality of the subsection 1, the matters to which the duty extend include in the particular the provision and the maintenance of the plans and the system of work that are, so far as is practicable, safe and without risk to the health. The making of the arrangement for the ensuring, so far as is practicable, safety and absence of risk to the health in the connection with the use or operation, handling, storage and transport of the plant and substance. The provision of such information, instruction, training and the supervision as is necessary to the ensure, so far as is practicable, the safety and health at the work of his employees, so far as is practicable as regards any place of work under the control of the employer or self-employed person, the maintenance of it in a condition that is safe and without risk to the health and the provision and the maintenance of the means of access to and egress from it that are safe and without such risk. The provision and the maintenance of a working environment for his employees that is, so far as is practicable, safe without risk to the health and adequate as the regard facilities for their welfare at work. These are the obligations of the employers toward the employee. The employer is obligated to protect the employees in relation to safety, health and welfare through the following procedures. First, to provide and maintain a safe plan and working system. Second, to put in a place procedures so as to ensure safety and health in the usage, handling, storage and transportation of the plant and supplies. Third, to provide information, instruction, training and supervision for new and old employees. Next is to provide and maintain a working environment that is safe and free from the health hazard. And lastly, to provide the necessary amenities for the welfare of those who are working. Untuk pengetahuan semua, Seksyen 15 adalah merupakan salah satu seksyen yang paling penting di dalam akta ini. Hal ini kerana seksyen ini menerangkan tugas-tugas am majikan dan orang yang bekerja sendiri terhadap pekerja-pekerja mereka. Next is Section 16, Duty to Formulate Safety and Health Policy. Except in such case as may be prescribed, it shall be the duty of every employer and every employed person to prepare as often as may be appropriate revise a written statement of his general policy with respect to the safety and health at work of his employees and the organisation and arrangement for the time being in force for carry out that policy and to bring the statement and any revision of it to the notice of all of his employees. Moreover, based on the Regulation 1995 atau lebih dikenali sebagai Peraturan Keselamatan dan Kesihatan Pekerjaan di bawah kurungan Penyataan Dasar Am Keselamatan dan Kesihatan Pekerjaan telah menyatakan the duty to formulate safety and health policy shall apply to all employers or self-employed person except those who have undertaking of not more than 5 employees. Okay, now we go to the Section 17, General Duties of Employers and Self-Employed Persons to persons other than their employees. First, as far as practicable, are not exposed to risk to safety and health. Second, provide the information on such aspect of the manners in which he conducts not to affect their safety or health. We still in the part 4, which is Section 18, Duties of Occupier of a Place of Work to person other than his employees. First subsection, as far as practicable, occupier of non-domestic premise must ensure all access and egress is safe without risk. The second subsection is a person who has by virtue of a contract or lease or otherwise an obligation of any extent in relation to the maintenance or repair of a place of work or any means of access thereto or egress therefrom or the prevention of risk to safety and health that may arise from the use of any plants or substance in place of work. Untuk makluman semua juga, sekiranya seseorang itu melanggar peruntukan di bawah Seksyen 15, 16, 17 dan 18, jika disabitkan kesalahan, ia boleh dikenakan denda tidak melebihi RM50,000 dan penjara tidak lebih 2 tahun atau kedua-duanya sekali. Okay, this is the last part that I will be cover, which is part 5, General Duties of Designers, Manufacturers and Suppliers. Part 5 of this act provide general duties of person who design, manufacture, import or supplies any plant in Section 20 or any substance in Section 21 for use at work. The duty under Section 20 and 21 is quite similar, which are to ensure so far as is practicable that the plans is so designed and the construct as to be safe and without risk to health when properly used. Second, carry out such testing and examination. And lastly, to make available adequate information of the plan and the substance. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Adam Zailani and my student ID is 2020-991223. And today I will continue to explain about section which relates to the general duty of employees at work. A. To take a reasonable safety and health for himself and other people that may be affected by his actions at work. B. To cooperate with any of his employer or any person in charge of the duty. C. To wear or use at all time the PPE or the clothing that is provided. Last but not least, D. To comply with the instructions or any of the measures that has been instituted by the employer or by the OSH itself. Moving on to the next sections, which is section 25. Duty not to interfere with or misuse things provided pursuant to certain provisions. A person who contravenes the provisions of this section shall be guilty of an offence, shall be liable to a fine not exceeding 20,000 ringgit or imprisonment for a term not exceeding 2 years or to both. No employer shall to be levied on any employees of his any charge in respect provided in the pursuance of these acts. Next, Section 27, Discriminations Against Employee. Part 1. No employer shall dismiss an employee, injure him in his employment, or alter his position to his detriment by reason only that the employee A makes a complaint about a matter which he considers is not safe or is a risk to health. B is a member of Safety, Health and Committee established pursuant to this Act, or C exercises any of his function as a member of the Safety and Health Committee. For Part 2, no trade union shall take any action of any of its members who, being an employee at the place of work. The explanation for Part 2 is same as Part 1. For Part 3, an employer who are convicted be liable to a fine not exceeding 10,000 ringgit or a term of imprisonment not exceeding 1 year or to both. For Part 4, notwithstanding any written law to the contrary, in addition to imposing a penalty on the offender, make or both of the following orders. A. An order that the offender pays within a specific period to the person against whom the offender has discriminated such damage as it thinks fit to compensate to that person. B. An order that the employee be re-employed in his former positions or where the position is not available in a similar position. Part 7. Safety and Healthy Organization. Section 28, Medical Surveillance. Where it appears to the Minister that in any of the industries or class or descriptions of industries, A. Cases of illness, B. Changes in process or substance use, C. Person below 16 years old, and D. Person employed in any of the occupations specified in the third schedule. Section 29. Safety and Health Officer. Part 1. This section shall apply to such class of industries as the Minister may by order publish in the Gazette specify. Part 2. An occupier of a place of work to which this section applies shall employ a competent person to act as a safety and health officer at the place of work. Part 3. The safety and the health officer shall be employed exclusively for the purpose of ensuring the due observance at the place of work of the provisions of this Act and any regulations. Part 4. The Safety and Health Officer shall possess such qualifications or have received such training. Part 5. An occupier who are convicted be liable to a fine not exceeding 5,000 ringgit or to a term of imprisonment not exceeding 6 months or to both. Section 30. Establishment of a Safety and Health Committee at the place of work. Every employer shall establish a Safety and Health Committee at the place of work in accordance with these sections if A. There are 40 or more persons employed at the place of work. B. The Director General directs the establishment of such a committee at the place of work. The compositions of a safety and health committee in subsection 1, the appointment of a person to be a committee shall be as prescribed. Every employer shall consult the safety and health committee to ensure the safety of the workplace. Section 31. Functions of Safety and Health Committee. The Safety and Health Committee, established at a place of work pursuant to the sections 30. A. Review the measures taken. B. Investigate a member employed consider place is not safe or there is a risk to the health. Matter brought to attention by an employer. And C. To resolve matter as in B or to inform Director General. D. Shall have such other functions as may be prescribed. Part 8. Notifications of accidents, dangerous occurrence, occupational poisoning, and occupational diseases and inquiry. In Section 32, Notifications of accidents, dangerous occurrence, poisonings, and occupational diseases and inquiry. Part 1. Employer must report to the nearest OSH office of any accident. Part 2. Medical officer must report to the Director General if he believes a patient to be suffering from any of the diseases that listed in the third schedule. Part 9. Prohibition against use of plant and substance. In Section 35, power to prohibit the use of plants or substance. A. Power to prohibit only by Director General. B. Director General may consult other government departments before making a decision. In Section 36, aggrieved person may appeal. A person who is aggrieved by an order made under subsection 35 bracket 1 may within 30 days of the order lodge an appeal with the Secretary to the Council, who shall transmit the appeal to an appeal committee appointed by the Minister under Section 63. Moving on to the Part 10, Industry Codes of Practice. In Section 37, approval of Industry Codes of Practice. Number 1. Only approved by the Minister upon recommendations from councils or the Director General. Number 2. May be amended from time to time. Number 3. An industry code of practice may consist of any code standard, rule, specifications, or provisions relating to OSH. B. Apply, incorporate, or refers to any document formulated or published by any body or authority.
Before I proceed with this presentation, I would like to introduce myself. My name is Gusti Farwiza binti Gusti Anuar, and let's proceed this presentation starting with Section 38. Section 38 is use of Industry Code of Practices in proceedings. In any proceeding brought under this Act or any regulation made under which it is alleged that a person has contravened or failed to comply with a provision of the Act or a regulation made under it in relation to which an approved industry code of practice was in effect at the time of the alleged contravention or failure. The approved industry code of practice shall be admissible in evidence in the proceeding in court, unless the court is convinced that the defendant comply in some other way that is at least as good as the provision of the code. A breach of the appropriate provision is presumed if a breach of the industry code of practice is proven at any significant time. As a result, employers should adhere to applicable industry standard of practice or implement procedures that are better than those stated in the industry code of practice. Although not legislation, Industry Code of Practice can be used to show that an employer did not follow the law, whether under the Code of Practice or his own better rules. So what do standard and codes mean? Standard is an operational principle, criterion, or requirement, or a combination of these, while codes can be defined as a set of standards, rules, or regulation relating to a specific area. Standard and code play an important role in modern safety, health management, and engineering. Written standard and codes that employees carefully follow can also decrease the company's exposure to costly litigation. Numerous organizations develop standards for different industries, which this organization can be categorized as government, professional organization, and technical or trade association. Next, the slide shows the example of codes which are code of practice on preventing and responding to drug and alcohol problems at workplace, code of practice on prevention and management of HIV or AIDS at the workplace, and code of practice for safe working in a confined space. Thus, we can see that standards and codes is very important. It also plays a big role in guideline for hazard identification, risk assessment, and risk control, which is also known as HIRAC, guideline for public safety and health at construction sites, and guideline on occupational safety and health.
We move to part 11, Enforcement and Investigation.
Section 39, the power of entry, inspection, examination, and seizure. The section highlights the power of occupational safety and health officer and what the officer can do when there is contravention or sekiranya berlaku sebarang percanggahan dengan akta ini. Powers of entry, inspection, examination, seizure may require reference to Criminal Procedure Code. We can see the application of this section by knowing the steps that an officer needs to be done if he believes that a place or a workplace has contravened the law. Before entering the premises, only the OSH officer may, for the purpose of carrying the objects of this act, at any reasonable time and upon the production of his certificate of authorization, enter, inspect, and examine any place of work other than a place used solely for residential purposes, provided that he may enter the residential place with the consent of the owner, or if he has reasonable cause to believe that the contravention of this act or any regulation met thereunder has or is likely to be committed. In this section, the OSH officer is given the authority to enter any premises in order to carry out the acts and related regulations objective. He does not need to obtain permission from the owner in some cases. It's essential to consider the concept of reasonable time and reasonable ground to believe. What is reasonable time and reasonable cause to believe? Okay, reasonable time refers to what time of the day they can enter the premise. This visit must be conducted at any reasonable time upon producing the officer's certificate of authorization. Reasonableness atau kemunasabahan depends on the facts of each case. However, reasonable cause to believe means with the issue of reasonable cause to believe arises when an officer needs to enter a residential place. He can do this by obtaining permission from the owner or when he has reasonable ground to believe that the contravention of this act or any regulation under the act has occurred in the residential place itself. The offence must be a serious offence and the offender should be brought to justice. The officer may also enter the residential place if he believes an offence is likely to be committed. When the officer enters the premises, the officer might begin examination and investigation. An officer may examine or investigate any plant or substance or article during inspection to find out whether the employer complied with the act or other related regulation. Second, direct the place of work or any part thereof or anything therein should be left undisturbed. Ia membawa maksud di mana ketika dalam menjalankan penyiasatan, seseorang pegawai yang in charge boleh mengarahkan sesuatu kawasan tu ditinggal tanpa diganggu langsung. When conducting an investigation, an officer may order that the location be left undisturbed. with the purpose of preserving the state that existed at the time of the accident as nearly as possible. Next, the officer will take such measurement and photograph and make such recording as he considers necessary for the purpose of any examination or investigation under paragraph subsection A, the previous one. This is because some type of evidence are perishable and site may be changed knowingly or unknowingly. All evidence must be captured as soon as possible. An officer also take measurement to obtain proper perspective, photograph and samples, and shall inspect and take copies of relevant documents. Get a sample of any products or substance found in the workplace that he has authority to enter, as well as the atmosphere in or around the workplace. Pegawai tersebut boleh mengambil sampel dari mana-mana artikel atau sebarang bahan bukti yang dia jumpa, di mana dia mempunyai kuasa untuk memasuki dan menggeledah sekitar kawasan kerja tersebut. If any individual employed in a place of work where any of the diseases listed in the third schedule of the Factories and Machinery Act 1967 or any disease included in any regulation or order made by the minister under this act has happened or likely to occur, they need to instruct the person to a medical health officer as soon as possible. In subsection 3, when an officer comes across a plant, substance, or article that he believes present a threat to public safety or health, he may order that to be dismantled, dirombak, examined, or tested at any convenient location at any reasonable time, as long as it is not destroyed or damaged in the process. He may hold and take control of it in order to inspect it, ensure that it is not disturbed during the examination, and ensure that it is ready for use as evidence in legal proceedings. Detachment refers to the act of holding something in one's possession, while possession refers to the act of having authority over something. Like I said before, the purpose of take possession is to examine, to ensure that it is not tampered with before his examination of it complete, and to ensure that it is available for use as evidence in any proceeding. In subsection 4, if the officer is medical officer, he may conduct any medical examination that may be required for the performance of his duties under this act or any regulation made thereunder, and perform any other powers that may be necessary or that are conferred under subsection 2 and 3. We move to section 40, entry into premises with a search warrant and power seizure. When a magistrate receives information under oath that there is a reasonable cause to believe that any article, thing, book, document, plant, substance, installation, or part thereof has been used or is intended to be used to commit an offence under this act or any regulation made thereunder, is in a place of work or residential place, he shall issue a warrant under his hand to an office name or referred to in the declaration. To enter into a place of work or residential place with a search warrant, an officer must have reasonable cause to commit an offence. The DOSH officer will request a warrant from a magistrate. So, to enter business premises or a residential with a search warrant, an officer must have reasonable cause that something on the premises, such as plants, substances, or other item, has been used or will be used to commit an offence. If there is a complaint from neighbours or employees, the DOSH officer may have reasonable cause to suspect. He must then submit this information to a magistrate under oath in order to get a warrant from the magistrate to enter the workplace or residential place. The officer must prepare a written information under oath that the magistrate must sign. The magistrate can only issue the warrant if an officer has reason to believe there is evidence of the offence in that location. Beside that, in section 41, entry into premises without search warrant and power of seizure. An officer may enter a premise without a search warrant when he has ground to believe that the article, thing, book, document, plant, substance, installation, or part thereof is likely to be removed or destroyed prior to a warrant being obtained. The officer may also enter without a warrant when he believes a serious offence has been committed. breaking, tampering with, or damaging the seal on a shred of evidence or part thereof without a valid permission or attempting to do so shall be an offence. In Section 42, power of forceful entry and service on occupier of signed copy of list of things seized from premises. If it is essential, an officer may, in the use of his authority under Section 40 or 41, first, break open an altar or inner door of a place of work or residential place and enter thereinto, forcibly enter the place and every part thereof, remove by force any obstruction to entry, search, seizure, and removal as he is empowered to effect, and detain every person found in the place until the place has been searched. This subsection seeks to sanction the forceful entry into premises by an officer in exercising his power under Section 40 or 41. Power of forceful entry can be exercised when the officer has a warrant as stated in Section 40 or when he has reasonable ground to believe that an offence under this Act or regulation has been or will be committed. Previously stated that under paragraph 42, subsection 1, D, he may detain every person found in the place until the place has been searched. But such detention does not mean arrest. It is only temporary detention, and this power of detention only exists during the search process. If the premises are unoccupied, the officer seizing any evidence or part thereof under Section 40 or 41 shall prepare a list of the things seized and deliver a copy of the list signed by him to the occupier or his agent present in the premises as soon as practicable.
Hello everyone, I'm back. You are with me, Hazirah Nisa binti Haznizam. Okay, now we will continue with Section 44, which is power of investigation. Firstly, an officer should have the power to investigate the commission of any offence or any regulation made under this Act. Secondly, an officer may exercise the special powers which are related to police investigation, except the power to arrest without any warrant given by the Criminal Procedure Code in any seizable offence. When his investigation has completed, the officer should immediately give all information relating to the commission of the offence to any officer in charge of a police station. And then, a police officer may issue a warrant and arrest any person who is believed to have committed the offence. A police officer is basically any member of the Royal Malaysia Police, which includes a constable, a corporal, and assistant superintendent of police. Next, Section 45, power to examine witnesses. Firstly, this section gives powers to an officer under Section 39 or 44 previously to examine and question orally any person who knows the facts of the case. Then, the person being examined is legally bound to answer all the questions and to state the truth. However, bear in mind the person may refuse to answer any questions if the officer failed to produce the certificate of authorization upon request by the person questioned, or if the answers of the question may incriminate him. An officer is bound by this section to inform the person being questioned that they can refuse to answer the questions. Thirdly, a person making a statement is legally bound to state the truth whether or not the statement is made wholly or partly in answering questions. Then, an officer who obtains information from a person should first inform the person of the provisions in number 2 and 3 above. Okay, statements given by the person being questioned should be written down in the language spoken by him, and the officer should read the report in front of the witness. Any correction may be made, and the statement should be signed by the person or affixed with his thumbprint. Proper techniques of interview should be used to ensure that the information is objective, accurate, relevant to events, and not influenced by personal feelings or opinion. Sometimes re-interview may be needed for clarification. Lastly, When an officer uses the assistance of an interpreter, any inquiry or request made on behalf of the officer by the interpreter is presumed to have been made by the officer for all purposes, and any response made to the interpreter is considered to have been made to the officer. Now, Section 46, Employer or others to assist officer. This section requires all persons at the workplace, such as occupier, employers, employees, subcontractors, agents, or others, to provide assistance to the officers exercising their powers under this Act. There are some types of assistance to an officer. It may include providing personnel to guide and assist him at the place of work, providing relevant information in relation to his task, for example, risks involved in carrying out the task like inspection, examination of plant or substance, some documents, for example, medical surveillance records, providing personal protective equipment like mask, respirator, glove, and others. Okay, that is Section 46. Now, Section 47, Offences in relation to inspection. This section provides a list of offences which is related to inspection duties by an officer, such as refusal to allow an officer to gain access to a place of work, obstructing them from carrying out their duty, concealing information regarding accident sites, things or persons, failing to produce documents, preventing another person from assisting the officer, and hinders or opposes the officer. Next, Section 48, Improvement and Prohibition Notice. This Act requires employers and occupiers to take action to improve standards of safety and health in the workplace as instructed by an officer. There are two types of notices which may be used in different circumstances, which are notice of improvement and a notice of prohibition. Now, what is the difference between improvement notice and prohibition notice? Improvement notice is issued when the defect is likely to cause bodily injury or is a serious risk. The officer must specify the section or legal requirement that is being breached, and the reasons behind that must be given. The period allowed to fix the fault must also be stated. Actions that may be necessary to put matters right should also be stated in the notice. Notice of improvement can be served on the person who is contravening or the person who is against the legal provision, or it can be served on any person on whom responsibilities are placed, whether he is an employer, an employed person, or a supplier of equipment of materials. Work cannot go on during the notice period or until the situation is rectified unless the officer gives permission to do so. Okay, that is improvement notice. Meanwhile, prohibition notice is issued when the defect is likely to cause immediate danger to life or property. The notice prohibits work activity which increases the risk to injury from being carried out. This includes prohibiting the use of operation of place of work, substances, plant or process at work when the risk of injury is considered imminent. The notice must state the matters that give rise to risk of a serious personal injury and may include precautions or steps that should be taken to put matters right. The use of any plan or the activities should only be continued after remedial action specified in the notice has been taken. Notice of prohibition can be served on the spot on the person undertaking the activity or on the person in control of it at the time the notice was served. However, notices can also be served by post to the appropriate address. If the officer is not able to establish the correct name and address, the notice may simply be addressed to the owner or occupier of the premise. Okay, now we have a list of OSHA 1994's regulations or order. Firstly, Occupational Safety and Health Employers Safety and Health General Policy Statements Exception Regulations 1995, which are associated with Section 16, Duty to Formulate Safety and Health Policy. as well as Occupational Safety and Health Committee, Regulations 1996, which include employees' involvement in formulating and reviewing the policy. And then Occupational Safety and Health, Control of Industrial Major Accident Hazards Regulations 1996, which illustrates Section 17, General Duties of Employers and Self-Employed Persons to persons other than their employees. And then we have Occupational Safety and Health Classification, Packaging and Labeling of Hazardous Chemical Regulations 1996. In Section 21, General Duties of Manufacturers as regards substances for use at work. For example, for chemicals, they should include Chemical Safety Data Sheet, CSDS. And then Occupational Safety and Health Officer Regulations 1997, like in Section 29, Safety and Health Officer, as they provide details of registration, notification, duties of SHO and employer, as well as Occupational Safety and Health Officer Order 1997. Next, Occupational Safety and Health Prohibition of Use of Substance Order 1999 in Section 35, Power to Prohibit the Use of Plant or Substance. And then Occupational Safety and Health, Use and Standard of Exposure of Chemicals Hazardous to Health Regulations 2000 in Section 28, Medical Surveillance, as they formulated a guideline on medical surveillance. Lastly, Occupational Safety and Health, Notification of Accidents, Dangerous Occurrence, Occupational Poisoning and Occupational Diseases, Regulations 2004. So guys, that marks the end of Chapter 7.1, Introduction of Main Parts of the OSH Act 1994. I hope you learned something today. That's all from us. Thank you.